My name is Tyler Vaughn. I represent the appellant in this matter, Janet Roland Burke. And Your Honor, before I begin, I would like to reserve 3 minutes for rebuttal. Thank you. Your Honor, we're here on appeal, to be frank, because the trial court found that Ms. Roland Burke, who is in her 60s, who's been receiving Social Security disability benefits since 2005 for, in part, memory deficiencies, for failing to remember certain prior injuries or prior medical treatments. We've got two.
We're going over a 10-year period, right? There's a couple of surgeries I would not remember. There's a bunch of things that the person denied ever having, and then tried to pin everything on either the apartment complex or the rug cleaning company. Is that true or false?
So for the, and just, Your Honor, just to clarify, are you referring to the treatment that she had in the past over the previous 10 years?
She denied all these things. The judge said, hey, you're out of here. I'm giving the ultimate sanction. And your complaint, I think, one of them is that, hey, there was no evidentiary hearing, correct?
That's correct, Your Honor. And Judge Velazquez, that would be pertaining to issue 2, which is that we're arguing that the trial court erred by not conducting this evidentiary hearing. And if I may kind of elaborate before we get to that point, the issue that we were trying to point out to the trial court during the hearing on the motion to dismiss was that if you go through the deposition transcripts, when Ms. Roland Burke is actually confronted about some of these prior treatments, she does, at this point, we have to remember that the defense had discovery in terms of from requests for production and answers to interrogatories where she had indicated in those interrogatories that she had suffered from prior back discomfort and back pain. She had those medical records reflecting the treatments that she received from the injuries that she's alleged to have incurred from the slip and fall in this specific incident that was never disputed.
Amended interrogatory answers?
I believe the interrogatories that I'm referring to.
Interrogatory answer says, and I quote, I have not, close quote, ever been in an accident where I have similar injuries.
So, and that's pertaining to the accident, Chief Judge. If I refer, Your Honor, to page 398 of the record, I believe it's interrogatory number 13, where she's talking about where she discloses, I've had prior back discomfort and prior back pain.
Oh, yeah, but she wants to characterize it as just sort of this garden variety, you know, when you sit too long and you stand up and your back is stiff, as opposed to she's doing surgeries and extensive treatment for her back.
That's correct, Your Honor. So she indicated during the deposition that she had prior back surgery, and she was alluding to, apparently she had prior back surgery right after she had her first son, and she believed that was in sometime in 2002.
She
That
said
had,
it's her nerves. I mean, did you dispute, I mean, I guess you do, but I mean, I don't know how you can dispute that she didn't, and whether it's sufficient to warrant dismissal is a different question. But she, to me, you look at this record, she clearly tried to minimize the problems she had with her back in the past, as opposed to, yeah, I've had all these problems, and guess what, now it's worse. She tried to minimize it.
and I think that's one way to characterize it, respectfully, Your Honor. I believe another way to characterize it would be, you know, maybe exaggerating on certain instances as well. But yes, minimizing and exaggerating. But the main point is that what we've learned from case law is that inconsistent statements, exaggeration, poor disclosure, or poor recollection, I should say, even lying in and of itself is insufficient to show fraud upon the court. I mean, fraud is you know, you have some sort of an overt act, like for example, if somebody's forging medical documentation to make their diagnosis more severe, somebody's forging the medical bills to show that the bills are higher than what they are, or hiring false actors.
Let me just pose sort of a small kind of hypothetical. Let's say, you know, everything that you know, your opponent is arguing about, how she characterized her medical history and what the trial court found. Just take that, okay, that's all true. What is your best case for saying, even if all of that's true, it's just not enough to warrant dismissal? Because it is a pretty high bar. So what's your best case for that?
And just to clarify, Your Honor, best case in terms of what would qualify as fraud?
Yeah, it's why this isn't enough.
So for one, there wasn't an evidentiary hearing, and the reason we think that's important is because during an evidentiary hearing with the plaintiff is, or whoever is alleged to have committed fraud, when they're put on the stand and the judge or whoever is cross-examining them, The trial judge has that superior vantage point to determine the credibility of that individual's.
When you received notice, or when you received this motion and notice of a hearing, did you ask for an evidentiary hearing?
At the time, Your Honor, I didn't
It's an
explicitly,
easy question, yes or no?
I personally didn't ask for the hearing, it's already noticed.
Does the lawyer below object to the way the judge was handled and not doing an evidentiary hearing? I didn't see one.
So I don't think there was an objection, and just to clarify.
So, were there any medical records that were not before the court in deciding this?
The medical records pertain to the treatment she received from the injuries from the slip and fall in the case.
That's passed.
I believe they had attached some of the medical records, and I do have.
As far as I can tell, we had all of her records since '99, when she was diagnosed with neuropathy and back pain, and her application for disability in 2002. There's an indication in 2002 low back surgery, but I couldn't find a record. There's 2008 low back surgery, a huge disc herniation with multiple epidural injections from 2008 to 2009, and 2015 Mease Hospital record, slip and fall while walking a dog. So what I'm asking you is was anything presented, was there something not presented to the judge that you're arguing about?
Not necessarily that something wasn't presented to the judge, and to answer your question directly, no, it was more so the interpretation or the characterizations of how she was answering these questions during the deposition. I think that was the biggest point of
Did
contention.
anybody say, okay, I'm bringing Ms. Rollenberg to this hearing, I'd like for her to testify?
Yes, Your Honor, I did. I had indicated to the trial judge when I noticed that she was leaning towards actually granting the motion. That's why I indicated to the trial judge in the, I believe the transcripts were provided in the supplemental record, that Ms. Rollenberg is here. She is prepared to be sworn in and to testify should the court have any concern about the issues of credibility. I think, again, the biggest point of all is that there may be some downplaying, right? Or yeah, there's downplaying, there's exaggeration or, inconsistencies, testimonial discrepancies. But that's what impeachment's for. That's what a cross-examination is for. When you have,
I know, I understand this is abuse of discretion, and we don't take it lightly. We don't see this as other, like an evidentiary ruling and things like that. This is the drastic remedy. But the question is this: if she doesn't reveal prior similar accidents and injuries, and doesn't reveal all these hospitals, and only gives one doctor in Tennessee, doesn't reveal the surgeons, doesn't reveal the pain management people doing the epidurals for 5 months, and all of that, and the defense finds it out, is that what you're saying, that's okay? I mean, why should we make someone go through the expense of trial to prove that someone is lying? Is that the justice system? Is that what we're supposed to do?
obviously, no, Chief Judge, respectfully. I think it's more so if you look at the interrogatories, they had requested any medical documentation or providers within the past 10 years. A lot of these that they're having points of contention for would have fell outside of that 10-year scope. I don't know if it really matters in your analysis, but I wasn't the attorney of record at that point. Regardless, the question was asked for the past 10 years. In terms of when they're confronting her about some of the treatment that she had not disclosed up front. Like, for example, there was a question about, well, did you ever suffer a prior fall that injured your lower back? And at first, she, according to the deposition, she testifies and says no. And they, well, you sure? Because I have this Mease Countryside Hospital record, or this ambulance record. And she says, oh, wait, I remember now. Oh my God, I believe it's on my son's birthday. And so it's showing that she's making this good faith attempt to try to remember some of these things. Again, she's been on Social Security disability for memory deficiencies since 2005.
Let's just assume that the doctor's office in Tennessee burned down. Let's assume Mease Hospital burned down. And your client, I don't know if you tried the case or not, but she lied about all this below and continued to. The defense never found it out.
I think,
So is it the defense's responsibility to go out and prove someone lying when they're not forthcoming in discovery responses under oath?
so if pertaining to the hypothetical, if that hypothetical were pertaining to the treatment that occurred again outside of 10 years, it does pose a very interesting question. I mean, No, we don't want the defense having to run around and make sure that everything is credible and verifiable, although I think that's kind of comes part of the job as the attorney of record. But we obviously don't want them to feel like, hey, we have to search for things in order to prove that this individual is lying. However, lying in and of itself, although it may be a very, frowned upon action by somebody, we're dealing with a plaintiff that's already going to have bias against their own personal experiences and injuries, what they're going through. But going back to the point of the evidentiary issue, is that's what impeachment's for. You sit them down in front of the jury and you impeach them on, especially if you.
Start talking about a jury, this is summary judgment. Wasn't part of your argument, oh, she had memory lapses, she forgot stuff, that was part of her problems, but was there any medical records to corroborate any of that assertion?
Yes, Your Honor, so
the judge did a weighing process, weighed that against the other medical records, said, you lose. Isn't that what happened here?
and that's ultimately what the trial court came to the conclusion. We think that a big issue is that Ms. Rollenberg wasn't given the opportunity to explain, or the trial court actually wasn't given the opportunity
You didn't
to
request
assess the
an
credibility of
evidence.
this.
You didn't request an evidentiary hearing. Once you essentially go down the tubes, you can say, hey, we want a hearing. We want to testify. I'm thinking you want your cake and eat it too. You don't get the benefit of a potential ruling and then say, oh, I don't like that ruling. Let me give you some reason to change it. It's like arguing after the judge does a ruling. That happens all the time, right? And the judge usually says something like, hey, you don't get to argue during my ruling. I'm going to finish the ruling, and that's the end of that case. Isn't that kind of what you're doing here? I mean, I don't have a problem with your strategy, but it's not the effect of it.
I think procedurally how it played out was sort of problematic. The defense files the motion to dismiss for fraud upon the court. They're the ones that filed the notice of a telephonic
The
hearing.
hearing's almost over. And you don't have a case that says, I am entitled to an evidentiary hearing even when I'm asked for one.
Conceitedly, right? There isn't any case law or rule that
Well, I
explicitly
know
states
this,
a hearing.
We Judge Sleet and I both were trial judges. We've seen this so many times, we could probably buy your farm. I'm just saying, I've been in your shoes, I've heard your shoes. You need to give me something more than what you have so far, to be totally honest.
So I think, with the defense having the burden by proving clear and convincing evidence that somebody's committing fraud, and then the court itself, according to the case
You
law,
don't just have a finding of fraud, there has to be a reason to impose sanctions. So
reasonable sanctions.
whether it's fraud or something else, there's sanctions imposed by this trial judge, and that's subject to an abuse of discretion.
That's correct, Your Honor. So you're right, there's other available remedies for sanctions for discovery violations, and I think that when you get to the level of the most extreme sanction of dismissing the case outright, when you're not able to assess the
So
credibility.
you agree with that? We're here to test whether the sanction was too extreme, not whether a sanction should have been imposed at all.
That's correct, Judge. Yes, Your Honor. That we're arguing that this specific sanction was too extreme. It was obviously an abuse of discretion, and I do briefly want to go over the standard review here, that for these motions to dismiss for fraud upon the court, it's not just a traditional abuse of discretion from my understanding, it's actually a more stringent view. And case law has taught us that when the trial court doesn't have an evidentiary hearing, such as the individual who's alleged to have committed fraud, and to testify, that it's an even further narrowed scope of review, because the appellate court is looking at the same record as the trial court. I think it's extremely important to have somebody testify in that circumstance, especially if you're considering to outright dismiss the case, to assess that credibility as the trial judge. You're able to not only hear their answers and determine whether or not their explanations for the discrepancies are.
Did you move for rehearing to allow her to testify?
There was an oral motion for rehearing towards the end, Chief Judge.
Well, that's when you kind of felt like the trial judge was not rule against you. I mean, it doesn't sound like you preserved this issue of demanding an evidentiary hearing. It just doesn't. I mean, strategy's strategy. I get it. I was a trial lawyer. We were all trial lawyers. You make decisions in the heat of the moment, but they have consequences up here. So it doesn't sound like you preserved.
Well, and to respond, Chief Judge, it would be that not having the evidentiary hearing doesn't necessarily need to be preserved for appellate review, because it constitutes a fundamental error. We know that the Florida Constitution allows.
Really, now you get deep in the woods, because you offer your client's testimony after the judge was getting ready to rule. So now we gotta decide, did the judge abuse his or her discretion in not allowing your client to testify? That's a lot easier than what we're deciding here. Because who can sit here and say that no other reasonable judge had enough information and was fully convinced that they could make a ruling at that time? Nobody can say that no other judge would have done it. So you be careful.
I understand where you're getting at. I think at that point, call it a mistaken, impression that we were under the belief that, Ms. Roland Burke was going to be required to testify. That's why I had her there next to me. But after hearing arguments of counsel, again, call it getting lost in argument. But after realizing that the judge was coming to her ruling, that's when we turned around and offered the testimony. And again, call it a mistaken impression or interpretation of how the procedural aspect of that plays out, with it being the defense's burden or the appellee's burden of proof, and to say that somebody's committing fraud, maybe, again, a mistaken belief that Ms. Roland Burke would have been required to testify. And I think that was also kind of further supported when you look at cases such as Howard v. Reich, even Duarte versus Snap-on Inc., where they state that the trial court lacked an evidentiary basis to determine fraud because no evidentiary hearing was required. And again, we do concede that there's no specific statute or rule of procedure that explicitly states a hearing is required. But when you get to that extreme sanction of outright dismissing a case, and all you have is just the record itself and no explanation as to the, or to determine the credibility of this explanation for the explanations of the discrepancies, it's just highly an abuse of discretion.
You're at 17, so you have 3 minutes left.
Thank you, Your Honor. I was just getting ready to ask for my time's up.
Yes,
I
sir.
will yield. Thank you.
Good morning.
May it please the court. Jason Nazarone on behalf of West Shore District. Based upon Your Honor's questions to opposing counsel, you all pretty much hit the nail on the head in this one.
Well, that doesn't mean you're winning. It's just that this is extreme. So get us over the line of you've impeached people with inconsistent statements, perjury, what have you, false affidavits. Unfortunately, yes, now. So here, it does appear that there's a couple of occasions when she's confronted with the specific record itself. I tripped over, I tripped over a walkway. But yet she still says that wasn't serious, I didn't have a complaint. So where does it become fraud?
I think the answer to that question, Your Honor, is in the case law, is the multiplicity of her statements. And let's just start, because I spent a lot of time looking at the record because I knew this case was going to be one where we'd have to look at the record a lot. We start with, Your Honor's pointed this out, answers to interrogatories. Anything prior, not an I don't remember, not a maybe, it's a no, none. Then we get to the depositions. We go to the depositions. Well, let's talk about this social, and I'm going to go in chronological order because I think it's easier. Let's start with the Social Security application. Testimony. It took me 3 years to get Social Security benefits. I had to hire an attorney to get those, but she doesn't remember that what was the reason for that? Well, I was having some memory problems. The record reflects that on that document, the memory problem was the secondary diagnosis. The primary diagnosis was back pain, low back pain.
Was there an initial denial?
There was an initial denial, that's correct. Then we go on, okay, well, can you tell me, have you had a history of back problems? Do you have chronic back pain? Chronic back pain was asked multiple times in deposition because that's what the records all reflected. Have you ever had a prior back surgery?
Well, let me just stop you right there, sorry to interrupt, but part of my understanding of when a dismissal for fraud is appropriate is when the fraud is such that it prevents you from having the information that you need to try the case fairly. And it seems to me that you have all this information. You maybe didn't get it from her, but It wasn't like you didn't have all the information. What she did not prevent you from having a full picture of her medical history.
Well, while that may be correct, Your Honor, and the one thing I will say that was incorrect in the initial brief, none of these records were produced during initial discovery. We had to go and find them. Okay, and
She
to
didn't
judge,
disclose all her physicians
she did not,
in her interrogatories?
not all of them, no. So
So
this,
she withheld
I don't, well, again,
names
go,
of physicians that had material information in their medical records?
I can't say that for sure, Your Honor, because we have to go back to what the question was, and I think counsel's correct that it was 10 years. But we still had to go and find this information. And then when we had the information, this is important, this is what the trial court found. We presented her with the questions. Did you have chronic back pain? Did you ever tell anyone there was chronic back pain? No. Well, I have a record here that says you did. Oh, yeah, that's right. Yeah, I did. So only when,
But you knew she had chronic back pain. That would answer the question, right?
but she's still lying about it.
Yeah, but you knew, and that goes to his argument about, this is cross-examination, this is undermining her credibility when you just try. You weren't prevented from knowing what you needed to know in order to defend the case.
But this goes to Judge Sleet's point. Is it our job to go out and find this information?
Well,
Is that what
according to
justice
the
is?
case law, it might be.
It might be, and that's why I
I
say,
mean, for a dismissal.
I understand.
Maybe it's not your job, it shouldn't be your job to go find it, but to get a dismissal, doesn't the plaintiff have to do something that prevents you from getting that information?
That's one
For
aspect.
instance, I've been treating with this doctor forever, I have all of the, he's got material medical records, and she doesn't disclose it. But somehow you find out about it. Maybe you look in another doctor's notes and you see this doctor's names but we wouldn't have that kind of situation as I'm understanding this.
No, we don't have it in this situation, Your Honor, but look at the number of times she denied all of this. Look at the number of times she said, no, there's nothing.
So is there case law that says if you do it enough?
Actually, there is the Ramey case that's cited in my brief, and I,
Case?
Ramey,
That's okay, you don't need to give me.
it was cited in my case, but they talk about, there are different situations. There's a situation where, oh, I missed one. Then there's situations where I missed 10, 15, 20. That's what we have here. This is a situation where we ask, did you ever have any back surgeries? I can't imagine forgetting a back surgery.
No, I think that's what the trial court said.
And that's exactly what the trial court said.
Yeah,
You
but
don't,
how do you forget you had back surgery?
back surgery aside, how do you forget 6 epidural steroid blocks? How do you forget trigger point injections? How do you forget hiring an attorney to get you Social Security benefits for back pain? How do you forget all of this? How do you forget that I tripped and fell over a root? I complained to not one, not two, but 3 separate groups, the fire department, Sunstar Ambulance, and the hospital, denying chronic pain. And then when you're showed the record, well, you told the hospital you had daily pain. No, I didn't. I didn't say that.
I have a question.
Yes, sir.
Before I forget, you were asking for fees in this case?
I don't recall, Your Honor.
Let's assume you're asking for fees in this case. Did the trial court award fees as this additional sanction, or the record was silent?
I think the record was silent as to that.
So do you have any authority for fees?
As I stand here today, no, Your Honor.
Okay, all
And I think going back to Judge Kelly's point, again, we have to look at the number. This wasn't simple forgetfulness. This wasn't something where she said, well, I don't really remember. It was, no, here's a document. Oh, yes, now I remember. That's what turns this into fraud on the court. That's what turns this into a case where the sanction, as Judge Vellante wanted to know, is this a reasonable sanction? It is absolutely reasonable. Counsel has brought up the fact that there was no evidentiary hearing. And I think, again, Your Honors all recognize this. It was not asked for.
Well, he asked to call his witness at the tail end of the hearing, is that correct?
He did.
And did the judge say, too late, I already made my mind up, or we're about done?
I actually pulled this up. This is record page 577. What the judge said was, the challenge I'm having is she denied all of it at first and then questions the veracity of the records. And when confronted, yeah, you have to admit it. So that doesn't seem to me to fall within the argument of it's made in good faith. I think if the judge, if the circuit judge really had an issue or wanted that type of testimony, she could have. I'm sorry, Your Honor.
Ms. Muscarella,
I believe so.
I mean, she's a business lawyer from way back when, on top of being a trial judge.
Right. And if a trial judge would have wanted to hear testimony, again, She was there, could have happened. But again, we have to look at that issue, and I know it's the second issue, but I don't need an evidentiary hearing. I don't need an evidentiary hearing. Things aren't going my way. Now I want an evidentiary hearing. That's not the way it works. If you really think, and counsel said this, you know, it was extremely important to allow her to testify. It was extremely important enough to allow her to testify. Counsel would have requested an evidentiary hearing prior to the hearing, would have done something more to ask for the court to take this testimony. But at the end of the day, would it have mattered? At the end of the day, there was deposition testimony under oath that she denied ever having these surgeries. And Judge Kelly brought it up. She said, I had a nerve problem. No, she had a lumbar surgery to the same area she's complaining of in this case. So what we have here, Your Honors, is we have exactly the right situation, the appropriate situation for affirmance of the trial court's order, because her misrepresentations went to the heart of her claim. She was claiming low back pain. She had not one, not 2 years of low back pain, chronic low back pain. And this is something that, to Judge Sleet's point, cannot be excused. It cannot be excused. There has to be a point where we say, you need to have truthful disclosures. Telling us only part of it is not enough. For that reason, Your Honors, we would ask that you please affirm the lower court's decision.
Let me ask you one question.
Sir.
I was on the Snap-on Incorporated panel with Judge Solari. We cited a case, Howard. Unless it appears that the process of trial has itself been subverted, factual inconsistencies or even false statements are well managed through impeachment at trial. What's the difference here?
You brought it up yourself, Your Honor. It has been subverted, because if we hadn't found it, if Meese had caught fire, if Tennessee had caught fire, how would we have found out about it? The only way you find out about it is from the plaintiff. That's how it's been subverted. Thank you very much, Your Honor, for your time.
3 minutes?
Thank you, Your Honor. I just want to point out just a couple of things in terms of the prior medical records and prior treatment providers. She did in interrogatory, I believe it was on page 598, if I'm not mistaken. She does disclose her prior medical providers, again, within that 10-year scope, and there was nothing to show that she's actively doing something to prevent the defense from discovering any type of material facts of the case. I think that was the most important thing in Morgan, if I'm not mistaken, and also Cox v. Berg, which is where the plaintiff essentially was giving different social security numbers, giving different names, effectively stymieing the defense's ability to discover that material information. They do have a duty on their end to advocate on behalf of their client and to go through full discovery and try to get to the disclosure of certain facts. But when you're asking for somebody's personal characterizations of what they've experienced in the past, compounded by the fact that they've been receiving Social Security disability benefits since 2005 for memory deficiencies, compounded by the fact that they're not given the opportunity to explain these discrepancies on the stand, along with the fact that she's claiming that she had a concussion, suffering further, if there is such thing as further memory deficiencies, and they're not able to fully recall, for example, that she had specifically lumbar surgery, but instead refers to it as, well, I was told it was for nerve damage, it was in my back. And then when she's asked about injections, she comes out and discloses, oh, I've had an epidural before. I actually had one right after I had my son, after pregnancy. But regarding the other injections, shots for pain injections, she's asked one time over the course of 2 separate depositions. I believe it was towards the end of that second deposition when she's asked about the pain injection shots. She's not even confronted when she says no. She's not even confronted about, well, do you recall having these in 2007, 2008? Again, no attempt to allow her to explain those discrepancies whatsoever. Your Honor, I did want to point out, Judge Sleet, about the Duarte case. I think that is very crucial here, and that is the most applicable in the situation there. There was an evidentiary hearing. Once again, no evidentiary basis to grant that motion to dismiss. Also, the trial court, or excuse me, I believe that this court here had found that the individual that was alleged to have committed fraud was suffering from memory issues. There was some sort of evidence of that. But more so, he was pointing out that these inconsistencies and even false statements, you said yourself, is meant for impeachment and cross-examination. Again, we're not asking that, we want people to come out and be able to file a claim and just make some sort of a wild allegation and lie about everything on the record. But when it's questionable in terms of, well, do they actually really do remember what happened? That's not enough to warrant a severe sanction as a dismissal in this case. If there's no questions, I do appreciate your time. Thank you.
Thank you very much.
Thank you.
Have a nice day. You're adjourned.
All rise.
Thank you, travel safely.
Thank you. Thank you. Have a good one. We got somebody else on. I didn't see you in here.
I gotta go all the way to the back.